The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have a couple of very interesting cases and some good lawyers. We welcome you here. In our first case, Hayesbert versus the Outback Steakhouse. Mr. Ariel, good to have you with us, sir.
Thank you.
And you're from Miss Hayesbert.
That's correct.
Yes, sir. Go right ahead.
Good morning. May it please the court. Judah Ariel on behalf of plaintiff appellant Joanna Wright Hayesbert, and I'd like to reserve 5 minutes for rebuttal. There are 3 issues in this appeal, each one independently warranting reversal. First is the exclusion of plaintiff's medical expert, Dr. Filler, due to the supposedly untimely supplementation of his expert report. Second, Batson challenge. And third, the revocation of plaintiff's trial counsel's pro hoc vice admission. Beginning with that first issue, the district court erred at each step of the analysis. So even if the new patient evaluation was a supplemental expert report, it was disclosed 1 day after the deadline. That is under Rule 26E, and this course...
So it was late?
It was late by about 15 and a half hours, correct?
Well, late is late.
It is, and we don't dispute that.
Well, you said, in your opening there, you said supposedly untimely. It was untimely.
Yes, that's...
Okay, go ahead.
We concede that it was untimely, but we submit that that minimal delay of less than a day was harmless or justified. Because...
There was an extended hearing on this before Judge Hayes, is that right?
There was, yes. And that, I mean, I would commend the court to actually review the entirety of that hearing.
Were you involved in that hearing?
I was not.
There was another lawyer, named Morgan?
Ms. Morgan, yeah, Mary Morgan represented the plaintiff at that, during trial.
We have a transcript of it.
And at that hearing, you saw very thoughtful responses by Judge Haynes to sort of a difficult situation of where there is significant delay between when discovery originally happened, when expert disclosures originally happened, and when the trial comes eventually a few years later. There are going to be problems about sort of where you freeze factual questions, both for witnesses themselves and for experts. And really, so that's the harm, that's the source of the harm that happened here, that Dr. Hayesbert had, she continued to live her life. She chose to retire from work, and she continued to receive medical care, including from Dr. Filler, who prepared this new patient evaluation sort of as a medical record arising out of the treatment of Dr. Hayesbert. But even if the new patient evaluation was properly excluded under Rule 37C, prohibiting Dr. Filler from testifying entirely was not justified under Anderson. First and foremost, the district court never found that plaintiff acted in bad faith, and that's sort of key to the analysis of the Anderson factors. Second, the only prejudice to the defendants that supported excluding Dr. Filler entirely was the claim that his testimony would be invariably tainted by what he learned since the time of his original expert report. That harm, however, would have existed regardless of when the new patient evaluation was disclosed. It would have existed even if the new patient evaluation had been disclosed the same day it was written, because that supposed harm is based on the passage of time and the fact that Dr. Filler learned new things as he treated the plaintiff. So to say that is the prejudice from the untimeliness of the supplementation that justifies sort of the very drastic sanction of excluding this key expert witness entirely doesn't quite make sense.
Was that your only expert witness?
No, there were two medical witnesses in particular. There were a couple other experts on non-medical issues that were withdrawn before trial, but there was Dr. Filler as the medical expert and Dr. Hyder. But that doesn't mean that the testimony that both Dr. Filler and Dr. Hyder would give or could give is duplicative. There were a few things that Dr. Filler could testify to that Dr. Hyder would not have been able to, and specifically, defendant argued the plaintiff didn't suffer a traumatic brain injury when she fell, and that any symptoms she was suffering were the result of sort of aging or pre-existing conditions. And Dr. Filler, however, could have testified and did testify during the first trial that the imaging of plaintiff's brain showed injuries that could only have been caused by a lateral impact trauma, that these weren't sort of progressive, degenerative, or chronic conditions we were looking at.
We're here on abuse of discretion review, and trial courts are granted judges are granted great discretion in running trials and making decisions in motions like this one. And I hear what you're saying seems to be an argument you might have made before the trial court, but here I don't see how anything that you presented would be sufficient grounds for us to find that that's an abuse of discretion.
Well, on an abuse of discretion standard, Your Honor, one can find an abuse of discretion both if the reasoning is not supported by logic, as well as if the district court fails to take into account the factors that are supposed to guide it in the exercise of its discretion. And here, when talking about the imposition of sanctions under 37C beyond the automatic sanction of exclusion, and the Anderson factors are supposed to guide the court's exercise of its discretion in terms of choosing what alternative sanctions are appropriate, if any. And here, well, first of all, there was no consideration of bad faith, which is the first factor in Anderson, and that's either in the initial oral decision or in the written decision on reconsideration.
And there are two of those. There's an oral decision and a written decision. And Judge Haynes didn't rush in through this. He listened to everybody and discussed it with them. Well, that hearing lasted a couple hours, didn't it?
Yeah, I believe so. Certainly Judge Haynes listened to the parties, engaged with the parties, but no argument about that. But still, in coming to the decision that she came to, she did not take into account sort of all four of the required factors, and I'd say especially the last two factors, deterrence and the availability of lesser sanctions. That first, the deterrence one is not supported, or the factual conclusions that she reached are simply not supported by the evidence. They're clearly erroneous because Judge Haynes talked about these previous issues concerning discovery, but all that had happened was really one set of requests to extend discovery that the magistrate judge denied, which is fine. And then the question of when subpoenas had to be issued. Did they have to be issued 2 weeks in advance of trial?
You do have a couple other issues, and your time is running down.
I appreciate
I'd like
that.
to hear about the Batson challenge.
Certainly, on the Batson issue, the first thing I would say is that we still have not gotten, whether at trial or in their briefs, really an explanation from defendants as to why these 3 grounds, youth, shipyard employment, and silence during voir dire, are how those connect to an issue in this case or to a permissible trial strategy. And specifically in their briefs, they seem to acknowledge that at least for 2 of those, for the shipyard employment and for the silence, that those aren't really reasons for striking juror number 32. And I think as a matter of logic,
And don't they also say you somehow waived your argument as to the shipyard reasoning?
they do say that.
Right, and what's your response to that?
Our response is that, one, you waive issues, not specific arguments, and 2, at trial, plaintiff's trial counsel responded in as much detail to that argument as defendant's counsel made.
Provided, which was
Yeah.
nothing. Defense counsel said nothing about why working at the shipyard made any difference to anything.
That's exactly right. And the fact that they're pointing to these characteristics that so clearly have no relation to any issues in the case, and are really unable to explain even why shipyard employment has any bearing on anything in this case, is strongly suggestive is that all of their reasons are pretextual. If you had a
Is there
real...
a case that stands for that proposition, that if one reason perhaps doesn't support the argument, but others do, that it sort of taints the other 2? I mean, I'm looking at the youth argument in particular, or the reason, and the fact that this juror is 10 years younger than anyone else in the jury pool. And it does seem to me that in a case that's heavily reliant on medical evidence and perhaps arguments about frailty of the plaintiff, that it could be a reason to disqualify or strike a juror if they are particularly much younger than the rest of the jury pool.
I don't have a specific case on point, but I think as a matter of logic, you don't point to, if you have a bona fide reason for striking a juror, there's no reason to point to other reasons that don't have the same connection. So yes, I would say even if the youth issue on its own might have been permissible and might have even been convincing, the context, the fact that there were these other 2 issues, the fact that they chose to strike juror number 32, but not juror number 26, who they had originally challenged for cause because of sort of cognitive issues with memory recall.
Right, so I wouldn't give up on the youth issue so quickly, because they did keep at least one older juror on there who had said he had cognitive issues. So if that's the reason they're striking the younger juror, it doesn't seem to hold weight since they left that guy on there.
That's absolutely correct, because we're talking, this is not just about age in the abstract, it's about juror 32's youth, the fact that he was in his mid-20s as opposed to other jurors in their 30s and 40s. And I don't think it follows.
Well, the younger jurors wouldn't have nearly as much life experience. And a lot of lawyers might be desire to have jurors who've been around the block a few times, have some life experience. And that's that would be a valid way to view things, for certain.
I certainly understand that perspective. We take a different one.
Pardon?
I certainly understand that perspective. We have a different view.
Well, that goes to age. So you strike the younger one and take the old one that been around the block and that knows life,
Except
has
that,
some experience.
except that their arguments for striking the younger one would apply even stronger to striking an older juror, especially a juror who's dealing with cognitive health issues, because the reasons were sort of the ability to understand, comprehend advanced medical terminology, advanced medical topics, and there's no reason to believe that a 25-year-old is less capable of doing that than someone older who's having memory issues. The other explanation they gave was that aging and the effects of aging on cognition in this case make age relevant. Well, again, that might make age relevant on the older end.
You know what that red light means?
Yes, I apologize.
You can finish your answer, but unless you want to borrow from your rebuttal time.
No, I'll just finish the answer very quickly, that even if age would be a reason to strike someone on the older end, sort of these concerns about cognition are not reason to strike somebody because they're too young.
And you have to take into account the nature of the case as well, and all that.
Thank you.
You've saved some time. Thank you. Mr. McGavin,
Good morning, Your Honor.
good to have you, sir.
Thank you. Members of the court, I'm John McGavin. Excuse me, I'm here on behalf of Outback Steakhouse of Florida. The analysis of this case, including the discussion about Dr. Filler, is tied very closely to the order that Judge Smith entered at the end of the decision to revoke the Pro Hoc Vice, because when that occurred, she was very clear that Mr. Hayesbert should not be participating any further in the proceedings going forward. And unfortunately, he did. So the trial, which lasted until almost 7 o'clock at night on that Friday, when I made that motion for mistrial and for revocation of the Pro Hoc status, we came back and the court had a hearing and then granted that motion. And then the plaintiff had to make a decision, Dr. Hayesbert, about how to proceed going forward. The court set a new trial date in February 2024 and ordered us to a pretrial conference to go over exhibits and witnesses. Dr. Hayesbert did not have a new attorney at that point, but when we had our meet and confer, Mr. Hayesbert was participating in violation of the court order, which we brought to the attention of the court. Then Dr. Hayesbert elected to take her voluntary non-suit, and the conditions were that the case was stuck in stone, so to speak, that it was to be where it was with experts and evidence, and the parties could not embark upon new discovery. Notwithstanding that timeline, we believe that Mr. Hayesbert got Dr. Hayesbert to see Dr. Filler. And the reason that was done is because at trial, Dr. Filler did not have causation opinions that were admissible in our view, and Judge Smith had some serious reservations about that. So there were definite holes in Dr. Filler's testimony that were evident during the trial. In particular, he had never spoken to Dr. Hayesbert, he had never examined her, and his testimony was quite vague in that he was describing that she had conditions that would be consistent with, without rendering an opinion to a reasonable degree of medical certainty that her condition was related. So there were obvious challenges, and those challenges had not been resolved, and Judge Smith's order even notes that the issue of the testimony of Dr. Filler was being left for the new judge to address. Consequently, filling the holes of Dr. Filler's testimony was an important component of any new trial. After the voluntary dismissal, the case was refiled again in June of 2024, and then we started back down the road again. Ultimately, if you examine JA 1009.
And if I recall, Judge Smith had stepped aside,
Yes, sir.
took senior status, and Judge Haynes was appointed.
Well, I think that Judge Haynes, or Judge Smith, was concerned that she had been the one to revoke the pro hoc vice status, and also that she was concerned that by granting the mistrial that there would be any appearance of unfairness to Dr. Hayesbert, who was entitled to a fair trial, just as we were on behalf of Outback. And so she asked to step aside, and Judge Haynes was then appointed. So, but the order that Mr. Hayesbert was to stay out was still in force and effect, and at JA 1009, Judge Haynes points out the number of times that he violated that order and stayed involved. And when we received on January 10, 2025, just essentially at the time of the pretrial, discovery's closed, 2 reports. One from Mr. Averitt, the liability expert, which was addressed to Mr. Hayesbert, and then this other report from January 3 of 2024, which was not addressed to Mr. Hayesbert, but obviously it was addressing the holes in the case, and we objected. And Judge Haynes, in her order, spent a great deal of time going through that history, but also trying to figure out how to remedy the problems, because one of the questions that I had asked during the trial of Dr. Filler, going to the causation piece, is, have you ever spoken to this person? Have you examined her? Do you know her medical history and the fact that she was reporting no complaints when she went to her health care providers? And to put Dr. Filler on the stand and then ask him those questions and then have him say no, or not at the time that I was examining him, made it very, very difficult to do the verbal gymnastics to properly have him testify. Plus, the plaintiff brought Dr. Hayter to trial. She played an extensive video of the DTI, which is the diffusion tensor imaging study, which shows, in her view, the effect of trauma and effect on the brain. And that evidence came in. We challenged it based upon some literature from the American College of Radiology that the DTI is not a reliable study. But nonetheless, she fully and completely testified to all of the things that Dr. Filler could have. Notably, in the first trial, plaintiff had asked to have Dr. Hayter appear and testify remotely during trial, and that led to a delay of a day in the trial, because Judge Smith said, well, wait a minute, you're making this motion the day before trial. Did you even make plane reservations, hotel reservations? Was any of that done? And there were 4 experts, 3 of which, all 4 were out of town, and she ordered him to explain, where are these people coming?
What do we make of the fact that in ruling on the sanction motion, the district court didn't specifically engage in the first Anderson factor, the bad faith factor?
Well,
I mean, those seem like, it seems to be that they are requirements. They're
Well-
not just suggestions.
Your Honor, I also believe that the southern states test can also be applied, because this was a supplement, and the Anderson case was a case of a default judgment. And even in a recent decision from the court in 2025, it's clear that there is some broader latitude following southern states. And I'd cite the court to Smith versus Devine, a January 2025 decision from the court. So I believe that the southern states factors are probably more applicable to this, because this is a failure to supplement. And of course, I think it's also implicit in Judge Haynes' ruling when she says, going back over the history of this case, which is an enormous record on what is a run-of-the-mill slip and fall case, frankly. So.
And if we disagree with you that southern states is the relevant and applicable standard, then should we find that the exclusion was exceeded the court's discretion?
No, absolutely not, because I think that the record is amply clear what Judge Haynes was referring to when she says, given the history of this case and everything that has occurred, I believe that this ruling is appropriate. And that's why I mentioned in beginning at JA 8008 through the balance of that opinion, her memorandum order of February 19, 2025, she talked extensively about the history of violating the court's previous orders and the interaction of Mr. Hayesbert in obtaining the involvement of experts and reports in violation of the court orders.
The Devine case you just mentioned, is that cited in your brief?
No, it was not. We found it afterwards, Your Honor.
Did you bring it to the attention of the court?
No, we did not. We did bring to the attention of the court the document that we filed just a couple of days ago to supplement the record, which was the designation of Dr. Filler. It's actually a supplemental designation of a retained expert, and we have filed a motion for that to be made part of the record.
That's a little late, isn't it?
It's very late,
All
Your Honor.
about delays.
It's very late, and the court may not consider it, so I concede that fact, Your Honor. Addressing the Batson challenge, this is a case where we had the difficult task of a very prominent provost from Hampton University, obviously a very accomplished person, Dr. Hayesbert, and we had to address the hard part that our evidence was that the changes on radiographic findings were age-related, and that any subjective complaints regarding decline in cognitive ability could be related to getting a little older, like that happens.
Like the juror that you left on?
Well, like that juror, what impressed me about that juror is he was very forthcoming about it. His demeanor, he was very conscientious about it, and he came forward, and I had a difficult decision on whether to leave him on. And based upon what I saw from him, I believed that he would be true to the jury instructions, and that he revealed information that he seemed quite confident that he would be fair. So that's why I left him on. As to the younger juror, I was concerned that his youth and failure to respond at all
Well,
left me
he
to
wasn't
guess.
the only one that failed to respond to anything, correct? There were 7 total potential jurors that failed to respond.
But not all were on the panel, Your Honor.
5 were.
That may be, yes.
That be. You left 5 on the panel that had been silent in the same way that the younger juror, that juror number 32 was.
They were older, so I'm sorry.
They were
Your
what,
Honor.
older? That's the distinguishing factor?
That's one
that they-
factor, and also.
What are other factors that distinguish those jurors from the one you struck?
They did not work at the
I
shipyard.
see that now. The shipyard I really wanted to ask you about, because I don't see anything, at least in the, well, maybe you can point me to somewhere in the record where you explain why working at the shipyard is somehow disqualifying. Did the provost work at the shipyard at some point?
No, Dr. Hayesbert never did. It's personal experience, having tried many cases, including having probably my biggest verdict ever, over $5 million, where we found out we had shipyard workers.
Where's that in the record as a reason?
It's not. We did not go into that detail.
Don't you have to have the reason contemporaneous on the record?
I think
Well, it's nowhere. You have to have the reason on the record somewhere. So this is just, he worked at a shipyard. That's all.
Well, my thought process relates to my extensive experience, and
Well, and if that was the case, and that being the case, it seems like, given your extensive experience, you would have made a record of that.
I regret that I didn't make a stronger record, but I think the judge, being in Newport News in Norfolk, is able to judge concerns that may come from that. She did not question that. And she also had the opportunity to judge my credibility and my responses to her questions.
She did have some concerns, particularly she expressed concern that defendants moved to strike juror number 26 for cause, but didn't strike juror number 26 using one of their preemptory challenges, who is Caucasian, but did strike the black juror.
He was older, and as I considered.
You're saying 26 was older.
Yes, he was quite elderly.
So it all comes down, you're saying it all comes down to youth.
Pardon?
You're saying that it all comes down to youth, that the distinguishing factor in your mind was that this person was young versus all the jurors that were selected, not that this person was black and the plaintiff was black versus all the jurors that were selected that were white and also silent.
It had nothing to do with race. It had everything to do with what was going to be the defense of the case, which is Dr. Hayesbert is a distinguished person of great accomplishment. And we have to say to her and to the jury, Dr. Hayesbert, you're well into your 70s now, and your complaints of cognitive deficits, memory, forgetfulness, distraction, in our evidence are related to age. And that was a significant factor that I felt on balance, deciding between a 24-year-old gentleman.
And which part of the record do you think you most clearly say that in the way that you're saying it now? It starts on JA 11. It doesn't go long. JA 11, 1100 to 1104.
It was a very short discussion, Your Honor. We did it as a sidebar.
Mm-hmm.
So that was very awkward. And at a sidebar, the
Right.
judge walked down around the bench, and we're at the sidebar with the court reporter.
And you're at the sidebar because there's jurors, or potential jurors sitting in the,
Everybody was there,
okay.
the veneer as well as the jurors.
So the lawyers came to the bench.
We came around to the right side of the bench, Your Honor, over to this side, and the jury was across the way.
But the court reporter was there with you.
Yes, sir. Court reporter was there, and the court did not invite or send the jury out so that we could have a fulsome discussion. I don't fault the judge for that. Your Honor, you raise a good question. I wish I had been more fulsome in discussing it or asked to do this outside the presence of the jury so I could explain it. But Judge Haynes was pretty quick to judge it and heard my thought process, and she ruled. But it was one of those times in the middle of a trial where you're at the sidebar, everybody's there, and I wish I had made a more fulsome record, but I had honest, truthful reasons. And that, I think that you're permitted also to judge demeanor and the way that's presented, and I think she did. I did not hear any questions from the court regarding Judge Smith's order to disqualify counsel. I'm not sure procedurally how we get to that, but the record is quite fulsome that the conduct of
Well, he
the...
mentioned that issue, but I don't think he got, I'm talking about your colleague there. He mentioned the issue early on, but didn't get to it
I understand.
in full.
So all I can
But
say...
You go ahead and say whatever you want to. That's right. We're gonna have him back.
I just have a couple of minutes, and I'll just say briefly that the conduct of the trial was unlike any I've ever seen, and the most shocking was when Mr. Hayesbert took his books and slammed them
Now,
on...
Mr. Hayford is the lawyer and who was the son of the plaintiff.
That's right, Your Honor. And took his books and slammed them down in protest over really what was happening. He did it a couple of times, which was quite shocking. And then injecting the issue of insurance, it was so patently obvious that even when he got to the point and said to the judge, "I will not mention the word insurance again," that we were having a major problem. And there were so many incidents of trial that it was so evident that we, on behalf of Outback, we're going to have a hard time having a fair trial, but more significantly, the disrespect to Judge Smith and to the process, to everyone involved, was overwhelming. But I think the record is clear on her thoughts in her order. Unless the judges have any further questions for me, I want to thank you for this opportunity to be heard.
Thank you, Mr. McGarrett.
Thank you.
Mr. Ariel, good to have you for rebuttal. Go right ahead.
Thank you, Your Honor. I'd like to hopefully get to 5 points briefly. First, Mr. McGavin talked about the new patient evaluation filling in sort of holes in Dr. Filler's testimony based on defendant's view of what was lacking in his initial testimony, his initial expert report. But I would just point out that Judge Haynes actually rejected all of those sort of pre-existing challenges, rejected the notion that he hadn't made an opinion to a reasonable degree of medical certainty, found that he was able to testify based only on his initial report as to causation. So there's really no need to do anything with the new patient evaluation, given what Judge Haynes actually ruled on the objections. Second, my learned colleague said that Dr. Hayter testified to everything that Dr. Filler could have. I would disagree with that in a number of ways, but sort of most specifically, Dr. Hayter talked about this being a coup contra coup injury with sort of bruising on both sides. Their medical expert looked at it, had a different view. Using DTI, using these advanced imaging techniques, Dr. Filler was able to see damage to the crust of the fornix that isn't otherwise viewable, and based on his expert opinion, determined that was, the word he used was pathogenomic, that when you see that effect, you know that the cause was a lateral impact trauma. It wasn't old age, it wasn't some sort of progressive disease.
Can you address the argument that your friend made about whether we should be applying Anderson or Southern States in this instance? In other words, whether the bad faith requirement is a necessary consideration?
Yeah, I mean, Southern States obviously governs the question of of exclusion of the undisclosed or late disclosed, whatever it is. But Southern States is a way of it guides the determination of whether the non-disclosure or belated disclosure was harmless or substantially justified. That's a question only with respect to the disclosure and to the exclusion of the thing disclosed or late disclosed. That can't guide, because those aren't the standards for the alternative or additional sanctions. And so, as Anderson said, the imposition of sanctions under Rule 37 is guided by these 4 factors. Southern States said, yes, except for the decision over whether to exclude. And then on top of that, sort of the reasons why given in Southern States as to why there's this different treatment, because there's guidance in the rule itself in one place and much more vague guidance in the other, would also support the notion that Anderson is what guides, whether to go beyond that automatic sanction. Number 4, I would disagree with my friend. The previous issues concerning discovery, none of them point to the violation of any court rule or court order, as we explain in our briefs. And finally, because I have 30 seconds left, with respect to the revocation of Mr. Hayesbert's pro hoc vice, that issue is determined by Ballou. It follows this court's decision in Ballou versus Leventhal that says there's got to be notice and opportunity to be heard, and that under Ballou.
Now, you said, you raised in your brief procedural due process. You're talking about the procedural due process to the lawyer or to the plaintiff?
Well, in this issue,
I think I read it that you're talking about as to the lawyer, but he's not a party here. That he was disqualified without procedural due process, but he's not a party.
he's not, but in this situation, and I do see my time is up, but if I may be permitted to just answer your question.
I'm just giving you an opportunity, because Mr. McGarren raised it for you.
First of all, you have statements from the Supreme Court in Richardson Merrill that if the attorney is dissatisfied with the...
But Judge Smith cataloged the misconduct thoroughly, talking about insurance before the jury. That, what my experience, that's a no-no in every court.
Understood, and I would point the court to Judge Haynes's review of the sanctions motions, where she found out that he didn't intentionally inject insurance into the case.
But that wasn't the only thing. She cataloged it all, and we don't get into it. But you're not talking about, I don't think in your brief, the due process rights of your clients. You're talking about due process rights of the former lawyer.
That's right, but even...
Well, you're on the wrong path.
Well,
Maybe he's got some due process rights to complain about, but that's not for this proceeding.
Well, here we would argue that the requirements for sort of third-party standing to a certain issue have been met. First, the litigant, Dr. Hayesbert, has herself suffered a redressable injury, that she herself has constitutional standing. Second, that... Maybe
she's got a claim against her son for acting up and getting thrown out of the case. That might be it.
Well,
but you're talking about the judge didn't treat the other lawyer, your predecessor in this case, fairly. And he's not a party here.
But by doing that, ended up denying the plaintiff sort of the counsel of her choice. and that she's in a position where she's allowed to assert, because
Well,
it also
he acted up
harmed.
and got himself disqualified. That's what happened. And the district judge, Judge Smith, an experienced district judge, threw him out. He revoked his pro hoc vice credentials and granted a mistrial to protect your client. And that's how we ended up here. But gave you another trial.
Well, and
Anyway.
And our argument is that that very well may have come out a different way had sort of the due process rights been followed, had Mr. Hayesbert and Dr. Hayesbert had an opportunity to.
So you admit you're talking about his due process right?
Yes.
That's what I thought. And I think I've given you an extra 3.5 minutes here.
And just like I said on that, we do believe that there would be third-party standing for Dr. Hayesbert to assert that if it's considered his right and not hers.
I understand your position.
All right. Thank you very much.
Thank you. And we'll take them, we appreciate counsel's arguments and submissions, and we will take the case under advisement, and we will now come down and greet counsel and then call the next case. Take your time. We'll wait till everybody's ready. Are there enough chairs there for everyone? Is there seating available for all the lawyers?
Yes, thank you, Judge.
Very good. Well, in our next case today, it's the United States versus Harvey Lewis and Aisha Adamson and Dennis Adamson. The first, on my papers, it shows the first of you that's going to speak is Mr. Diamond.
Good morning, Your Honors. If it please the court, my name is Mark Diamond. I represent Ms. Adamson.
Good to have you with us.
Thank you, sir. Concerning the misprision charge in its jury charge, the
That's
district...
interesting that you're starting off with the misprison issue, and it's the lesser of the offenses charged here by quite a bit. I mean,
What should I
a
speak about?
3-year
What have you-
maximum, 3-year maximum punishment, and we got a bunch of Hobbs Act offenses that are 20 years each.
Right. My client was sentenced
Not
to...
for her, right?
Not for her.
Yeah.
She got
Not
a
for his
she
client.
got a 6-month sentence. So I have to be very careful about what I say. I don't want her to get any more time than she earned. So concerning the misprision charge, and I can, would you prefer I start with the speedy trial issue, or?
No, I'm what
Okay.
you do,
I
what you
want to
wanna
hear
do.
about
Okay.
what you're talking about.
You talk about what you want to talk about.
All right, sir.
That's
Thank you.
fine. I don't know. I'm just commenting.
I understand.
I can make an observation.
Absolutely correct. So concerning the misprision charge, the district court declined to include the statutory
Were you
element.
one of the trial lawyers?
I was not. I was not.
Had you ever been involved in a misprison case?
No, never in my life. And I don't know
I was
anybody who
involved in
has
a few.
been. Really?
I've been involved in some. Yeah.
How long ago? I hate to ask.
Oh, it's been a while. It has an interesting spelling. Do you notice that?
I was mispronouncing it for about 3 months before misprision. But concerning, getting to that charge, the statutory element that the trial court declined to charge was that the felony had to be a federal felony in order to convict Ms. Adamson. And the Fifth Amendment right to due process and the Sixth Amendment right to jury trial entitle the defendant to jury determination, quote, of every element of the crime with which he is charged beyond a reasonable doubt. The district court twice charged the jury that the underlying crime had to be a felony, but twice left out that it had to be a federal felony before it could convict Ms. Adamson. Now, this is relevant because...
Are you arguing both that the jury needed to find that she knew that it was a felony and a federal felony? Because in Olson, the Ninth Circuit actually rejected that
Right.
federal felony argument.
I'm not arguing either at this point with the judge's patience. What I'm arguing what I'm arguing precedes that argument. What I'm saying here is that regardless of whether or not Ms. Adamson knew that the underlying felony was a federal felony or not, the fact remains that the felony that she was alleged to have concealed had to be a federal
The
felony.
underlying felonies were essentially robberies.
Robberies, possession of a
In
weapon.
commerce.
That's right.
Like convenience stores.
Right, that's right.
A slew of robberies of convenience stores. And they happened to be federal felonies under what we call the Hobbs Act.
You know that, and I know that.
I
The
know,
trial
that's
judge-
exactly right. You're saying your client
Right.
didn't know that.
No,
But I think-
I'm not saying-
but-
I'm saying the
but-
jury
but-
didn't know that.
And a common person on the street may not know that, but they
Right.
know that a robbery is a bad thing.
True,
It's a rough crime.
Right.
Armed robbery, shooting in the ceiling,
right,
yeah.
absolutely. But of
That's-
course, she was not charged.
That's about
with-
as serious
But-
as you can get.
But
Yes,
to Judge Berner's point, the Ninth Circuit, I think, helps you
Yes.
if you are arguing that the jury should have been instructed that she needed to know at least that it was a felony. Perhaps not that it was federal, but at least that it was a felony, because otherwise she didn't know what's the crime that she's committing.
That's correct, Judge. But before I even get there, my point is that the jury had to know that it was a felony, and there was no evidence
That's why I
here.
said instruct the jury.
Correct. But regardless of whether my client knew it was a federal felony or not, the jury had to know it was a federal felony, and there was no evidence in this case from any witness or any other evidence that the underlying crimes were felonies. The judge knew that, the parties knew that, you knew it, I know it, but the jury didn't know that because they were never told by the court that that the underlying crime has to be a felony, a federal felony, in order to convict Ms. Adamson. And here's a reason
And
that...
you have the Ninth Circuit case
Right,
that helps you a little bit.
so let me get to that.
And
So...
other cases go the other way.
Okay. So let me discuss the other case first. This is the Evans case that was brought to the court's attention, a Fourth Circuit case, which says that the issue of the federalness of the crime is a jurisdictional issue, not something that's, there's no burden of proof on the prosecutor to prove that the defendant knew that the crime was a federal felony. Our argument is that had the court charged the jury that Ms. Adamson failed to report her concealment to a federal judge, I'm arguing the wrong point, I beg your pardon.
That they're supposed to report to the federal judge.
That's right.
The crime been committed.
So, all right, so here's one reason to think that the jury would not have known that this was a federal crime. If the jury was not told that it had to be a federal crime, if the jury was told and could have found that it was not a federal crime, When Aisha and my client, Ms. Adamson and Mr. Lewis, spoke with one another on February 15th, Lewis was in Western Tidewater Regional Jail on state charges only. He wasn't indicted on federal charges until May 18th, which was three months after their conversation, and he wasn't arrested on federal warrant until the day after that. His first appearance in court was July 1st, which was 5 months. So my point is this: the jury could well have believed that Ms. Adamson was not interfering with a federal crime, that it was a state crime that he was interfering with. If the court had charged the jury properly, that they had to find as a first matter that this was a federal crime, they could have acquitted him on this charge.
You could still prevail on your argument, throwing out
Okay.
all this federal stuff, because that's a jurisdictional hook. And she may not have needed to know, and the jury may not have needed to know to convict her of that, but she at least needed to know that it was a felony. And in my view, that's where the jury charge might be improper.
That the court didn't specifically charge the jury that it had to be a felony.
That she knew it was, that she had knowledge that this was a felony.
Right, okay.
How do
So,
you get past, assume you're right.
Right.
How do you get past harmless error?
I'm sorry, which case, Judge?
You ever heard of harmless error?
No.
You haven't.
No.
It has to be prejudicial error under Rule 52 of the Federal Rules of Criminal Procedure.
Right.
And how do you get past harmless error? The government asserts harmless error here and briefs it. And you haven't mentioned it. But you're out of time, but I suspect you'll have some.
Very briefly, so the jury would have acquitted my client on these charges if she was properly charged on the misprision charge. Also, incidentally, the accomplice charge also has a federal requirement, and the judge didn't charge the jury that had to be a federal crime on the accomplice charge. But as for the misprision charge, you're correct, Judge. You can go one way or the other. If you want to go in the Evans case, you find it's a jurisdictional issue. I think the court jumped through hoops to come to that conclusion. A statute says what it means, and the statute says that it has to be a felony, and it has to be a federal felony, and the court did not charge the jury that it had to be a felony or a federal felony. That's a simple argument, Judge. And how you go on that, and whether you stick with Evans or go with what the Ninth Circuit
And you
goes.
don't want to engage in harmless error. Okay.
That it was harmless error?
No, I
How
gave you
could
a
it be
chance
har-
to explain it.
How could it be harmless error if
I
they would
just
have
gave you a
acquitted her?
chance to explain it because they argue it.
Right. I appreciate that. It was not harmless error because she would have been acquitted had the
Well-
jury properly charged the jury.
Was she only charged in one count?
Charged him on 2 counts. One was the accomplice count and one was the misprision count. So there were 2
One was
counts.
what?
I'm
The
sorry,
misprison.
accomplice after the fact and misprision.
She
So
get a concurrent sentence?
she got concurrent sentences, yeah. She got 2
Concurrent sentence
6-month
may
concurrent
Have something to
sentences.
do with harmless error.
Yeah, that's right. Thank you, Judge.
Thank you. Ms. Engler? Ms. Engler,
Good
who
morning.
do you represent now?
Good morning. May it please the court, I'm Cecilia Englert, and I represent Dennis Adamson. Mr. Adamson doesn't contest that
Now, were you involved in the trial?
I was not, Your Honor.
So we don't have anybody here who was involved in the trial then? I don't think.
Not on behalf of Mr. Adamson.
What happened to those lawyers? I assume they were appointed lawyers. Somebody must have released them and appointed you all.
I believe I replaced one of them as
I mean, I have on
appellate
my
counsel.
papers here that the three lawyers here now are appointed, and I really appreciate that. But I assume they were someone before you that was in the case too that was appointed. But anyway, you go right ahead.
Mr.
You represent Dennis.
Dennis Adamson. Mr. Adamson does not contest that the 5 Suffolk robberies were properly joined for trial, but what he does contest is that the
He was
ports...
convicted of 5 robberies, what, over there in Suffolk?
That's correct. He does,
That's where they went into the convenience stores and shot in the air and the ceiling to get everybody's attention,
correct,
and then robbed the place and took off.
correct. He
So
does...
what kind of an error can you claim that would be prejudicial enough to get them out from under this?
Well, our argument is that a 6th robbery that occurred in Portsmouth should not have been joined
The 6th one was
together.
over in Portsmouth, and how far away is that?
About 18 miles,
18 miles from Suffolk.
correct. Well,
And so that's out of
From-
town.
from
They
the,
left town, but they left in the same car, didn't they?
well,
Wasn't he robbing in Portsmouth with the same car?
there was evidence,
Same getaway car?
well, I'd like to distinguish that a bit, because the car that we're talking about was seen in a videotape of the last Suffolk robbery, only that one, not in the prior 4 robberies. Secondly, in the Portsmouth robbery,
It had only been seen in one of the 5 robberies.
correct,
Okay.
that car was evidence in
I'll
only
accept that.
one of the 5. The
Wasn't
last,
there also a large gap in time between the robberies?
there's
How
a
much
gap
time?
of 8 months between the last Suffolk robbery and the Portsmouth robbery.
There's a temporal issue that you,
There's a temporal issue, and secondly, as far as the same car being used, there's no allegation that Mr. Adamson drove that car, well, away from the crime scene in the Portsmouth robbery. In that
are
one,
you talking about the crime scene in Portsmouth?
Portsmouth, correct. He asked for a ride from his girlfriend, she dropped him off, and then 10 minutes later, he asked for a ride again.
It was 8 months after.
It was 8 months after, and the use of that car was different. It wasn't the same. He had asked for a ride, and Miss Ely happened to be driving the same car.
How much money did they steal at these different convenience stores?
I don't remember.
What kind of haul did they make?
It
That's
was,
what they call
it
it,
was
I think.
different, but I'll say that the haul was a lot greater in the 5 Suffolk robberies. They came at night.
But the
when
haul
the
wasn't near as much as they had hoped for, I don't think, in some of these stores.
I can't say how much they were hoping
Well,
for.
you might, you're the only one we got here right now talking to you. You don't know. You don't know how much was stolen.
There were, well, different amounts in different,
Well, you had the record.
that's
You know more
true.
about the record than I do.
That's
You
true.
spend more time with it than I have.
That's true. If I may, I would like to emphasize a couple of things. One is the severance issue. The most important thing I want to emphasize is that there was overwhelming evidence in the Portsmouth robbery and much less evidence in the Suffolk robberies. And this goes to the great prejudice that there is in combining the two in one.
Overwhelming evidence of the Portsmouth robbery.
Of the Portsmouth robbery, correct.
You said robberies, didn't you? I thought there were just one.
There
in
was
Portsmouth.
one Portsmouth
That
robbery.
one robbery in Portsmouth the proof was better,
Much better,
much better.
much better. And
And
so
it was
that,
thinner for the other 5.
compared to the other 5, and I'd like to briefly address the government's argument that there was a limiting instruction, and I want to emphasize to the court that because of this great difference in proof, the limiting instruction is not enough to counter the prejudice. And I would direct the court's attention to 2 cases.
Are you complaining about the joinder or the failure to sever? What's the issue?
Well, I'm jumping to the prejudice because prejudice is,
Prejudice from what? It's got to be from an error.
yes, the prejudice of joining the two
The joinder.
goes to both the
That
joinder.
would be from the indictment then. You're talking about there was a prejudicial joinder in the charge returned by the grand jury.
There were 2 mistakes. One was the prejudicial joinder, for which prejudice is an issue. Second, the denial of the severance, for which prejudice is also an issue.
That the judge wouldn't fix it by severing your client or the Portsmouth charge?
The Portsmouth charge.
The Portsmouth charge and your client.
My client in the Portsmouth charge.
So you wanted that severed?
That
from
case
so
severed.
You've got a joinder problem, you attack it by joinder, you attack it by failure to sever.
Correct, both by
Okay.
the amount of
And what's
prejudice.
the law in this circuit? And I think generally in federal
Well,
courts on severances and joinders. It's pretty strong.
it is pretty
for the
strong on
prosecutors,
joinders.
isn't it?
There's,
It's really strong for the prosecutors. I think there's like a presumption that those who are charged together are tried together.
there may be a presumption, certainly, and that is why we're not contesting the Suffolk cases. That was charged together, that was charged as a conspiracy. But I think that just because the same offense is charged does not automatically mean that you try them together. You might have an assault on federal property in Washington, D.C. You might have another assault on federal property in California. That doesn't mean you're going to try them
Well, but
together.
that's not what we have here.
No, it's not what we
No-
have. But I'm
There's nothing
attenuating,
about California.
I'm just attenuating
We
the
got
facts a
Portsmouth
little bit.
in the same
Portsmouth?
car.
Well, okay, the same car was involved, but we have different law enforcement agencies, different jurisdictions. And I would like to talk about the limiting instruction for a moment, because there was such a difference in the proof in each case. United States versus Fouts from this circuit cautions that where there's such a difference in proof, where there's a marked difference in the strength of the government's evidence, quote, "We cannot presume that the jury adhered to limiting instructions and properly segregated the evidence into separate intellectual boxes." And this reasoning was followed in United States versus Hawkins, where even though there was a limiting instruction, the court found prejudicial misjoinder, where there was overwhelming in one case, but not in the other. I'd like to just very briefly turn to the 404B evidence.
You know what that red light means?
Oh, yes, I am out of time.
You-
I apologize.
I'll give you another 30 seconds.
Okay. I'm talking about the text that was introduced by the government. This was sent by Mr. Adamson to Ms. Eli of a photo of her nude and of a gun. This was not relevant to any element of the offense. It was also not probative of any fact and issue, and it painted Mr., especially compared to the weak evidence in the Suffolk cases, painted him as a threatening person because this was a picture of a gun. She testified that she considered this a threat. It also painted him as a reprehensible person, that he would post a video of his girlfriend. And with that, I will
Thank
wait
you
for
very
my
much.
rebuttal. Thank you.
And you have some rebuttal time also. Mr. Wagner,
Judge, nice to see you.
it's good to
Morning.
see you, sir.
May it please the court. I'm Rob Wagner. I represent Mr. Harvey Lewis in this case. I was not counsel at trial. Mr. Woodward was counsel at trial. The money that was taken in these various robberies was relatively low when we look at federal robbery cases. $900 in one, $900 in another, $2,000 in another, $1,109 in another. But our issue, Judge, for Mr. Lewis focuses on counts 3 and 4 of the third superseding indictment. The victim in the case was asked the question whether this robbery occurred in 2022. And the victim answered that, yes, it did. And there was no subsequent correction to that. And that is the basis for our sufficiency argument here, that it is the government's burden to prove beyond a reasonable doubt each and every element of the offense. And that date that was cited by the victim in the case left that particular issue in doubt.
Weren't there videos of the crimes?
There are.
And
there are,
aren't they
Judge.
date stamped?
They certainly
And those
were.
were in evidence?
They were in evidence, but the principal witness for this robbery.
But the date stamp is ample proof, Mr. Wagner.
I would disagree with the word ample, but it provided some measure of
It can be.
proof.
We have to view it in the light most favorable to the prosecution. I mean, you know that. I mean,
I can't argue with that, Judge, but you also have to find that the evidence was sufficient beyond a reasonable doubt
that's
to
exactly
convict
right.
Mr. Lewis. And we submit based on that discrepancy in the evidence that the government failed to meet that standard.
Is that the only issue you
That's the only issue I present today, Judge. I rely on my briefs for the remainder of the issues, the other issue, the speedy trial issue.
I really appreciate you being involved in this case, and I have utmost respect and admiration for your work.
Thank you, Judge.
I've known you
appreciate
for a
that.
long time.
Thank you.
Sir. Thank you, sir. Now, Mr. Muzzy,
Yes, Your Honor, thank you.
good to have you. Did you try the case?
I did, Your Honor.
No?
Good for you.
Good morning, may it please the court. I'm Anthony Mosey for the United States. I'd like to address the issues in the same order that the defense addressed them, and that begins with the misprision statute. Your Honors, because the conduct forbidden by that statute, which requires the active concealment of a felony, is wrongful regardless of the underlying penalty of the felony, and because the word felony is nested, embedded within the jurisdictional hook of that statute.
How is it wrongful if she doesn't know it's a felony?
Your Honor,
When concealment of a felony is what makes it a crime.
the statute requires active concealment of after someone has knowledge of the actual commission of the
Of a
crime.
felony.
Correct, Your Honor. And in this case, we're talking about a Hobbs Act robbery. Those particular Hobbs Act robbery.
So what evidence is there in the record that the defendant knew that robbery or felon in possession were felonies?
Your Honor, there is evidence in the record, and if you can allow me to just briefly address that. So she was talking with her romantic partner at the time, Mr. Lewis, over a jail call, several of which were admitted into evidence. She talks and says to him that he should have disappeared this stuff, which we argued in our closing and at rebuttal meant gotten rid of the gun and the bullets, which would have been used for these offenses. The jury saw a form that she filled out to purchase a weapon for him previously, for which she used his actual debit card, and that after removing those items from his car, the jury heard evidence that she ran into a federal agent, an FBI agent, and at the time was told that it was likely that Mr. Lewis would be indicted. And at that time, she was actually concealing the keys to his car in her underpants on her person. So given that.
In none of that description, did you use the word felony? My question was, what evidence was there that she knew that these robberies and the possession of that firearm were felonies?
Your Honor,
She clearly, I mean, crime, yes. Felony, that's the question I have.
the suggestion is both that she was told that he could be indicted. As the court's aware, indictment means that someone has been committing a felony.
The court's aware of that.
means
Is she aware of that?
Lawyers might understand it.
That's correct, Your
But
Honor.
someone walking down the street might not understand it that way.
I'll concede that there's no evidence in the record that she knew that particular felony was punishable by more than a year.
So if we conclude then that the Ninth Circuit was right and knowledge of felony status is required, how was the error not harmless?
The argument.
If we conclude it was error.
I concede, Your Honor, it's not the strongest argument. I think that the evidence that was before the jury was that she was told that he could be indicted.
The evidence was told by the FBI agent, or what?
I don't recall which specific agent, because at the time it was joint FBI and local authorities,
But
Your
one of
Honor.
the investigators told her he could be indicted.
Correct.
And did they tell her that she knew that it had to do with the robberies of these convenience stores?
He was in custody on state charges for those robberies at that time, Your Honor, yes. So that's the evidence we have. Your Honor, I concede again that I don't believe someone specifically used the word felony with her.
Did anybody mention the federal charges? Or was the FBI present when this happened? I mean, the FBI is federal.
Not for...
That's in the statute too.
Correct, Your Honor. The FBI was not present while she was removing the items from the car, but this is sometime later, I think about 2 hours. There is an FBI agent present at that time, and there's evidence in the record that she was told that he could be federally indicted for this, or would likely be federally indicted for
Is
this.
there
She
any
was told federally indicted.
I believe so, yes, sir.
Well, I wish you could say she was told that.
I can find that in the record.
One way or another.
But even if she was told he was going to be federally indicted, assuming that's the case, she was not told he was going to be indicted for a felony. That's the part I really am focusing on, not the federal jurisdictional hook part of it, but the thing that makes it a crime. Concealing a felony is what is the crime. So that,
Concealing a federal felony.
right.
That's correct, Your Honor, and I think this is, if I may, I think this is why the Ninth Circuit's opinion in Olson should not be followed by this court. So for a couple of reasons. The first is that word felony is sort of nested or embedded
Wait,
within
can we get back to the, I did ask two questions that I still want an answer to. The first one was, well, I think I asked this one, whether there was evidence, I didn't ask this one, whether there's evidence that she knew he was a felon, so that she would know that he was a felon in possession.
Circumstantial evidence, Your Honor. Again, there's the purchase of a firearm that she said was being used for her own personal use. That record was admitted into evidence.
So because she lied on the form, basically, saying it was for her own personal use, that's some indication that an inference could be made that she knew she was getting it, that she had to hide that she was getting it for him because he was a felon.
That's
Is that
correct.
your sort of argument? Okay, then I want to go back to, you were about to tell me all the reasons we shouldn't agree with the Ninth Circuit, but my very first question was, assume we do conclude that the Ninth Circuit's analysis is correct, and so there was error. How was that error harmless?
Again, Your Honor, because of the fact that she was told that that he was going to be indicted, because of the fact that she was speaking with him while he was in jail, and I think because of the fact that any average person would assume that a robbery involving weapons would be a serious crime or a felony.
So
But-
and so you're saying that the jury heard all of that and would have convicted her regardless of the improper jury instruction?
Correct, Your Honor. I think that there is...
Assuming the jury instruction was improper.
That's correct, assuming that the jury instruction was improper, Your Honor. And in some ways, this is a bit of a chicken and egg problem. We, as the government, wouldn't have been allowed to introduce evidence about the fact that this was in fact a federal felony because that wasn't an element of the offense. Arguably, that could be prejudicial, in fact, to Ms. Aisha Adamson had we brought that information in. But I do think there is evidence in the record, again, circumstantial, and I want to be clear about that.
But that's what she's charged with, so I don't know how it could be prejudicial to say it was a federal felony. Doesn't the indictment say?
Again, it's a bit of a chicken
That's
and
what the
egg problem.
indictment says. But go ahead.
So with respect to Olson, Your Honor, that opinion, I think doesn't, we start with the text in statutory interpretation, and here we're dealing with a statute that begins talking about the actual commission, and then there's the second part of a felony cognizable by the United States. And even the Olson opinion concedes that this jurisdictional hook is not something that the government has to prove as an element or prove knowledge as an element. I think it's analogous to that United States versus Evans case that this court decided in 2023. That involved an arson statute that prohibited the willful setting of fires without authority on federal land. The defendant in that case argued that the government should be required to prove as an element that he knew that it was in fact federal land. And this court said, and reasoned no, that the wrongfulness of the act was the setting of the fire, and that the fact that that the Congress had decided to protect federal land was simply the jurisdictional
Right,
hook.
and the wrongfulness of the act here is concealing a felony. So how does she know she's committing the crime if she doesn't know it was a felony?
If I can answer that question, Your Honor, if Congress in Evans had decided to, instead of, say, public land, said Native American reservation, or perhaps a military base, like the base in Norfolk, I don't think the analysis in that case changes. It's simply that Congress has decided to protect a particular area of its jurisdiction and provide certain penalties for that. Here we have two statutes right next to each other, accessory after the fact, 18 U.S.C. 3 and 18 U.S.C. 4, misprision. And they're both sort of working in concert with one, accessory after the fact, which provides for just offenses against the United States as the jurisdictional hook. And then right after that, you have misprision, which provides heightened penalties for felonies up to 3 years, whereas accessory after the fact is just half of the punishment assigned to the underlying crime. It's similar to sort of the enticement cases that this court has dealt with before, whether or not a minor, the government's required to prove knowledge that the person targeted is under 18. So in trafficking cases, if the child is under the age of 18, that's 24, 23 under Title 18, this court has held the government's not required to prove the knowledge that that individual is under 18. There's a similar statute, just general trafficking of adults, 24, 21, and there the penalty is much less. The wrongful conduct is trafficking here, and in accessory after the fact and in misprision, you are concealing some sort of crime. Misprision is just dealing with Congress has decided to punish the concealment of felonies more harshly. And that's, I think, what the Ninth Circuit hasn't really reconciled within Olson. The Ninth Circuit's talking about Lee Perota, and I think had the benefit of reading Ruan and Rehaif, some of these other subsequent decisions from the Supreme Court that talk about the presumption of scienter. And that presumption really attaches when you have an act that, but for that particular element, would be totally innocent or something that we would want a society to encourage. Ruan, as the court is aware, involved a doctor who was charged with controlled substances offenses. And in that case, the Supreme Court said that, well, you do need to, in fact, prove that he wasn't acting, that he didn't have permission to distribute these drugs because we want doctors to distribute drugs. And the same thing in Rehaif. People can lawfully possess firearms. However, in order to convict them of unlawfully so, the government has to prove that they knew that they were, in fact, prohibited from doing so because of their status. That's not so in misprision, because the statute has been interpreted since the 1930s to require this concealment element. We're far from...
When that misprision statute was adopted, like when the country was formed?
It was, Your Honor. It was in the Crimes Act of 1790 with the first Congress. What happened was that, this is in sort of some of the law review articles that the Ninth Circuit talked about, that statute had not been really used until the 1930s. During that time, there are several decisions that say that we've gone far from the hue and cry practice of common law England. We have a modern police force. We don't need the populace to sort of go up in arms when we hear about crimes.
It's a form of obstruction.
Correct.
And I remember we used to sometimes plea bargain down to misprison because it had a lesser penalty than the obstruction statute.
It's commonly used in that context, Your Honor. That's right. And I think the word misprision of felony is perhaps not well applied here. It really should be called concealment of a felony, because that's what the elements of this crime have been interpreted since the 1930s. There isn't a constitutional issue here with roping in, sort of these parade of terrors. The Ninth Circuit talks about, charging people because a bunch of boys have stolen apples. What we're looking at here is knowledge of the actual commission of a felony and that you have to take an affirmative act to conceal it. That alone is enough to sort of avoid constitutional issues, and I think distinguishes this from all of the other statutes that the Supreme Court and this court have looked at, where we say we do include this additional knowledge requirement.
And the evidence here that she had knowledge of the actual commission of a felony is the FBI told her, or somebody, FBI or state agencies told her that he was likely going to be indicted?
Yes, after she's removed ammunition from his car, after she has told him that he should have gotten rid of the stuff.
So that, yeah, that's right, that was after. So how did she know it was a felony when she did it?
Because the misprision statute, Your Honor,
Because you're
is,
saying she learned that we could infer that she knew it was a felony because the FBI agent told her he was going to be indicted. But when she committed the crime, she didn't know that. She hadn't talked to any FBI agent. So how'd she know it was a felony then?
the statutory language requires that she did not make, I believe, as soon as possible, made known to some law enforcement. So at the time that she's in that vehicle, she's not with law enforcement. I suppose she could have picked up the phone and called her, but the clearest
Well, how long
opportunity.
after she concealed it, did she have this encounter with the FBI agent?
About 2 hours, Your Honor. And that's the clearest opportunity for her to say, there is something going on here. There were things in that car. So and frankly.
The crime is when you find out about it or discover it, and then you're supposed to report it.
The act of concealment is required. That's the element of it. And so the concealment here, is that she's still
failing.
hiding. Correct.
Is that she what? The concealment is?
She's still, at that point, concealing from the officer the things that are in the car, the fact that she has the keys to the car on her person at that time. All this was information that would have been useful to the government in sort of
And you said to
identifying
the
these
officer,
perpetrators.
was that the time it was the FBI agent or the time it was a state officer? You said you didn't know when the FBI guy came.
I know that the
agent
FBI
came.
agent was present. My understanding is there are also local agents there as well.
So then,
So the only felony, I'm looking at the statutory language, the only felony that's really at issue, because it's the only one she could have had knowledge of the commission of, is felon in possession of a firearm. There's no allegation that the basis of the misprision conviction is knowledge at the time that she met with the FBI agent of the other charged crimes.
There is, Your Honor, the superseding indictment includes the possession of a firearm, possession of ammunition, and also the Hobbs Act robbery.
And she was told all of that by the FBI agent at the time?
She was told that he was likely going to be indicted, and he was in jail for the robberies that had been committed. The purchase of the firearm had happened, I believe, some years earlier.
Now, was that a Suffolk robbery or the Portsmouth robbery?
Mr. Lewis was only involved in the Suffolk robberies, Your Honor, and if I may.
That was Suffolk.
Correct. To briefly touch on the issue of joinder, Your Honors, the defense focuses first on the geographic sort of disparity between these incidences. I confess that Suffolk is different than Portsmouth, but we're talking about a distance of less than 20 miles. The conduct here, the scheme, the common thing was that Mr. Adamson was in the business of robbing these commercial establishments while masked and while using a gun. He was unable to do this last robbery with Mr. Lewis because he had already been arrested at that point. Furthermore, with respect to the temporal time, this sort of 8 months gap, there's actually a larger gap between the robberies he committed with Mr. Lewis. The first of those were in 2020, and then there's about a 2-year gap until 2022. Mr. Lewis is arrested in January of that year, and then we have the robbery in Portsmouth later in October. But putting aside those sort of, I think, somewhat granular distinctions, there's a wealth of evidence that the jury saw that's overlapping, and that goes to both the appropriateness of the joinder in this case and also the fact that it was harmless. First, There was video surveillance of all of these crimes, and it's difficult to convey that on the record before this court, which is on paper, but it was something that the jury saw over and over again and that the government relied upon in our closing and in rebuttal. Mr. Adamson is a larger individual. He's about my height. The way that he moves on video is somewhat distinctive. He has a lazy eye, and that was visible in video stills from the very first robbery in 2020 in Suffolk. It's visible in one of the robberies that happened about the middle of the scheme in Suffolk. One, as was identified by one of the witnesses. And finally, Ms. Ely testified that he, of course, has a lazy eye. The relationships between these individuals was something that Judge Walker highlighted in why joinder was appropriate. Dennis and Aisha Adamson are brother and sister. Aisha Adamson is romantically involved, or was romantically involved with Mr. Lewis. He actually sent her letters from jail in which he was trying to coach her on how to testify and place him as sort of a false alibi. And finally, Ms. Ely, who was involved with Mr. Adamson at the time, who was really overlapping with all of these. She could identify him in multiple of the stills. Her car was used in both the Portsmouth robbery and the final of the Suffolk robberies, which sort of deteriorated into a shootout. Finally, Your Honors, with respect to Mr. Lewis, counts 3 and 4, the evidence is overwhelming that the correct date of that offense was in 2020. It was simply a misspoke thing by the prosecutor. Your Honor, I see my time has expired. If I could briefly conclude.
Anything else? No. Anything else?
No.
Thank you very much.
Thank you very much, Your Honors.
Appreciate your work. Mr. Diamond?
Thank you, Your Honors. I finally woke up. So there was no mention of a felony. There was no mention of a federal felony between Mr. Lewis and Ms. Adamson. There was no mention of a felony or a federal felony by the FBI agent. And Ms. Adamson had no record, so you can't assume that she might have known what a felony is by the description of what Mr. Lewis was making. So for these reasons, Your Honor, I think you're correct. I think that this case should be reversed because there was absolutely no evidence that a felony had been committed, that she knew a felony had been committed. Let me make one final argument if I have 10 seconds.
Didn't he direct her to buy the gun? So wouldn't that be evidence that she knew that he couldn't buy a gun because he was a felon?
So, no, I don't think that's true.
Well, why would he have then directed her to purchase it?
Well,
rather than do it
even if that were
himself?
true, why would that indicate a felony?
Because he was ineligible to purchase a gun.
He was ineligible, but how would she know that that was a felony?
Well, I'm asking, she knew that he was ineligible to purchase a gun. Is that right?
honestly, I don't
She
recall any
wasn't,
evidence of that.
she was, when she said on the form, did she indicate that it was for her use, that she was buying it?
No, she didn't.
Why was she buying it?
I don't know. I don't know why they didn't question that, but I don't recall that. I may be wrong about that. But again, why would that
The
indicate?
fact,
We get to answer the question.
Yeah, I know, I'm sorry.
We ask the questions. You
Who's
answer.
asking the questions here?
Listen to her question.
the fact that she was purchasing the gun for him and then giving it to him rather than him doing it himself
Right.
is some evidence that she knew that he could not lawfully possess it.
It is, but not
Okay.
that it was a felony. Your
I think
Honors?
he's finished.
He's finished. He only got 1 minute.
Anything else?
I had one very quick thing, if you don't
All
mind.
right.
So, even under Evans, the case should be reversed, because under Evans, the court reversed the conviction in that case. Why? Because the judge told counsel that he couldn't argue that this was a federal felony. And it might go to the issue of knowingness, mens rea on the crime. So while it wasn't relevant to the burden of proof of the prosecutor, the jury had to believe that this was a federal felony. I'm sorry. That the jury could have been convinced, it should have been, the judge should have allowed defense counsel to argue that she did not know this was a federal felony as a means of limiting the mens rea, showing that she didn't willfully break this law. And the judge refused to do it, and it was for the same reason in Evans reversed, because the judge didn't allow the attorney to make that argument. Same thing happened in our case.
We understand your position.
Thank you, judges. Thank you for your
work.
patience very much. Thank you.
Appreciate it. Ms. Engler?
Thank you, Your Honors. I would just like to respond to a few of the points that the government made as far as Mr. Adamson's claims. First, that they talk about the way that he moved, and I think there was no testimony, well, there's very little testimony that examined the way the person moved in all of the videos to connect that they were all the same person. The government also mentioned that Ms. Ely testified that she could identify Mr. Adamson from the videos, but her testimony was impeached very completely as far as being able to identify him by what he was wearing. Counsel, she testified that she recognized the shoes that he was wearing because they purchased those together. She testified she recognized the black shorts he was wearing because they purchased them together, but it turned out on cross-examination that she began dating Mr. Adamson in December of 2020 and began only after that time was shopping with him, and those robberies, where the shoes and the shorts were the way she identified him, those robberies occurred a month earlier in November. So her credibility, her ability to identify Mr. Adamson based on what he was wearing was completely impeached. I'd like to conclude by saying that the government was able to bring in the Portsmouth case and identify and bolstered its weak evidence in the Suffolk cases by bringing in the Portsmouth case. That had much more compelling evidence, and they also brought in irrelevant character evidence that likely affected the outcome of the Suffolk cases. And so Mr. Adamson requests that this court reverse his convictions.
Thank you very much. We appreciate having you here. And I want to particularly, we're going to adjourn court here, but I want to again say how much we appreciate the work that all of you have done, and particularly these defense appointed lawyers who got in after the trial. We really appreciate your help, and we couldn't function without folks like you all. And Mr. Prosecutor, you've done a very commendable job, and it's very good to have you here. We'll come down and greet counsel and adjourn court.
This honorable court stands adjourned, signed, die. God save the United States and this honorable court.